Henny.
Thank you. Te rangatu, paumua o te reo o te whare, tēnā koe. We all agree that things must change in terms of creating an environment where integrity, accountability and transparency actually count for something. And one of the clearest indications that things are changing is to be able to link to the Ministry of Economic Development website normally, and I pick up what Charles Cheval has been saying about it's actually down at the moment, but normally we can do that and have immediate access to the papers that are on there. And I refer in particular to the Cabinet paper that proposed this bill a mere 6 weeks ago. There's no need for applying for material under the Official Information Act or panicked calls to the Minister and the Minister's officials for a briefing. It's all there on the website, as clear as day. I have to say I like the sound of the proposals in the paper dated 3 May 2010. They tell me that under the Financial Advisers Act, advisers will now have to register, obtain authorisation, comply with the competency and conduct obligations and make a full disclosure before providing advice to a client. The paper goes further and promotes the establishment of a regulatory framework that is designed to encourage public confidence in the integrity and professionalism of financial advisers. As every member of this House knows, the issues of integrity and accountability in the finance sector are absolutely pivotal. Given this, I was somewhat surprised that out of the 93 submissions received on this, only one submission came from Māori. Mind you, that was a Māori submission which is from a fairly substantial one, and it came from the Māori trustee. The Māori trustee wanted amendments to the bill to clarify and limit the scope of estate or interest in land and to provide an express exclusion for the Māori trustee in respect of the Māori trustee's core statutory functions. They recommended that in order to limit the uncertainty in respect of estate and interest in land, and subsequently to lessen the impact this uncertainty has in respect of leases, licences and mortgages, that Section 5 of the Financial Advisers Act should be amended. That amendment is to insert a definition for estate and interest in land which provides that estate or interest in land does not include advice, guidance or recommendations relating to the granting of any leasehold interest or licence right or any form of easement or mortgage in respect of land. Now that all sounds pretty technical to me, but I have it on pretty strong authority, that is the authority of the Māori trustee, that such a definition would be a key way of protecting the interests of Māori landowners in respect of estates and interests in land, and that's something therefore that we want to promote. The other key issue put forward by the Māori trustee is to exempt the Māori trustee in line with its previously exempted statutory functions. These include obligations under the Māori Trustee Act 1953 and Te Ture Whenua Māori Act 1993 in respect of interests in Māori land and the holding and investing of money on behalf of the beneficial owners of such land. The reason put forward by the Māori trustee is that there is already significant transparency, control and oversight over the operations of the Māori trustee. This is by virtue of the Māori trustee being a Crown entity for the purposes of reporting. It is also demonstrated through the Māori Land Court's oversight role in respect of the various trusts for which the Māori trustee is responsible. Another means of ensuring there is sufficient transparency, control and oversight is through the funding arrangements and reporting requirements with the Crown. Mr Speaker, I am not an expert on the Māori trustee by any means, but I do believe that the issues raised in their submissions are worthy of further consideration of the House. Finally, I note the concerns that have been raised about some of the changes in the legislation in terms of what impact they will have on consumer protection. Some key stakeholders have been concerned about the flexibility that has crept in through the exemption of financial advice. This would have the effect of excluding a large number of organisations in which financial advice can be justified as incidental rather than core to their business. This could mean anything from a car rental company to a retail firm discussing hire purchase requirements. I think the hub of their concerns rests around what the term incidental means and how it is interpreted. In worst case scenario, that might mean people having a tutu with financial advice and getting away with shoddy advice on the flawed basis that it is not a central component of their business, thereby meaning that they don't have to comply with the registration or authorisation process. The last thing we would want to see is that the very people we are seeking to protect are unwittingly being exposed to yet another level of risk without the protection we envisaged would be possible in the legislation. Finally, Mr Speaker, I remind the House that Māori-generated economic development will play a significant role in the future of our nation. The last thing that any Māori shareholder or business person wants to see is another blue chips disaster blighting our financial horizons. The Māori Party supports this bill and encourages further debate and consideration of the range of issues that clearly still require further thought. Kia ora.
David, clean.